By the 15th century, it was becoming clear that there were problems in the way the common law operated. The procedures of the common law courts had become slow, expensive, and very technical. The solution came with the development of what is known as equity. Despite the development of common law courts between the 12th and 15th centuries, the king himself continued to be another source of law. Citizens could petition the king directly to hear their complaints and provide a remedy. For a time, the king himself dealt with these petitions, but as the work increased, he passed on his senior legal advisor, the Chancellor, and eventually set up a special court, the Court of Chancery, to deal with these petitions. What is important is that the Chancellor dealt with these petitions on the basis of what was morally right. Unlike in the common law courts, the Chancellor would make his decision not according to any precedent, but according to his own individual sense of right and wrong, and the merits of the particular case before him. This led to the development of a system of legal principles known as equity, which was different from the common law and which created new rights and remedies. For example, at common law, the main remedy that a person could obtain was the remedy of monetary compensation, which is often known as damages. However, in equity, more flexible remedies were developed, such as a remedy called specific performance. This is an order telling a person or organisation that they must perform their part of a contract, rather than pay monetary compensation. Another equitable remedy is a remedy called an injunction. This is usually an order to stop a person doing a particular act, such as acting in breach of contract. In time, however, the procedures of the Court of Chancery became expensive, and it took a long time for cases to be dealt with by a judge and for a decision to be given. In 1873, the common law courts and courts of equity were combined by an Act of Parliament, called the Judicature Act 1873. So today, all courts deal with both common law and equitable principles and remedies. So equity has added new principles to the body of common law, and remedies for those who have suffered an injustice, such as the remedies of specific performance and injunctions. Another way in which equity is still visible in the English legal system today is in the operation of what are called equitable maxims. These reflect principles derived from equity, which the court may sometimes use as guidelines. One memorable equitable maxim states that he who comes to equity must come with clean hands. This means that to be granted a remedy in an equitable matter, the claimant themselves must have shown proper conduct and not have behaved in an improper way. Another equitable maxim is equity follows the law. This means that courts deciding equitable matters must not needlessly depart from the principles of common law. So you can see that in some ways, equity is still important in the common law of today.